category is listed as the media item and relates to the photocopied article that was given out to all the board members. As some or all of the Board of Education may know, there was an article in Sunday's newspaper that raises certain policy and legal questions for this board to consider. So at this time, I would like to ask our board attorney, Bob Martinez, to frame the issue and comment on it.
Madam President, during the winter of 2006-07, the Finance Committee of the Board asked me to examine the possibilities of creating a contractual environment within which Mr. Nemeth, the then Board Secretary, could exercise his right and probably long overdue opportunity to retire in a manner that was convenient and effective for the Board. I examined various regulations that were pertinent to it and identified our alternatives. There are many different retirement systems in the state of New Jersey, and the rules differ among each one. In the case of the TPAF, Teachers Pension and Annuity Fund, the ability to re-employ a retiring executive is much different and more generous than it is in most other pension systems. Essentially, there were two options that the board had in the circumstances as presented to me. One would have entailed inviting Mr. Nemeth to take the summer off and then come back as a regular employee of the board for whatever duration pleased it. The alternative was to acknowledge the opportunity for Mr. Nemeth to act and work independently of the board and to pursue what he expressed was his desire to enter the consulting business on a broader basis than just dealing with this board, so he could have multiple clients and wouldn't be obliged just to this board. That's governed by a different set of rules that involve certain tests of independence. Faced with the facts as presented at that time, I made a determination that it was preferable and desirable and certainly consistent with law that the board consider entering into a consulting agreement, and that was the subsequent course of negotiation which the board adopted in April. About a week ago, Mr. Wolf inquired of me as to whether or not that arrangement, that contractual arrangement that the board had previously approved, was consistent with the law as it applied to other cases. And I advised him that I believed it was consistent, that the other cases did not apply to this situation, that Mr. Nemeth's arrangement met the test of independence provided in the regulations. I did not hear further from Mr. Wolf after that exchange of brief emails, and until the article appeared on Sunday in the Trenton Times. Evidently, there is dissatisfaction on Mr. Wolf's part as to my answer and the legality of that arrangement. I stand by the judgment that was made at that time. Certainly, that was not a board judgment. That was my judgment to make. I believe it is the correct judgment, and I believe it will be upheld if it's reviewed. It's unfortunate that we are confronting this in the manner that we are. I have an obligation to represent all members of the board fairly. In a situation where there is a disagreement among board members publicly about a judgment that I make, I feel that in the interest of continuing my tasks on other unrelated issues, I cannot proceed being distracted by one that is in dispute. And therefore, I'm advising you that it's my intention to recuse myself from anything further to do with this issue. And I further advise you that you should obtain special counsel to give you independent advice as to whether or not this was a correct course to follow, and to interface with any regulatory authorities that may choose or you may initiate a contact with to confirm the correctness of that advice. This is not unusual. As you know, we have backup counsel in various places for things when situations like this arise. And you do have available to you the firm of Sills Cummis, which is your default counsel on labor matters. However, I would recommend to you, in a case as technically complex as this, which involves tax and pension issues, that you go with the best person in New Jersey handling this stuff on the private side. And that's an individual by the name of Sam Halpern, who's a solo practitioner and pretty much does nothing but this kind of question. I think the efficiency of having someone with that expertise on the issue would serve the board's best interest well going forward into wherever that may take you or you may choose it to go. I have Mr. Halpern's resume here. If you'd like to look at it, I urge you to do so. Got a few people down there and a few people here. I've checked with him. He does not have any conflicts of interest that would preclude him from accepting an assignment from you. His rate is $247.50 an hour. That's because of a discount that's applied for public sector clients like this. So I'm sure will be able to advise you very competently should you choose to undertake that recommendation as I'm presenting it to you. I'm happy to answer any other questions you may have about the matter.
Are there any questions from the board related to what Bob's discussed here?
Bob, I had a question. Treasury spokesperson Mr. Perkis is quoted in there as saying that they review these cases, instances on a case-by-case basis when it's brought to their attention. Is there some mechanism where boards are able to present before board approval a certain arrangement to get essentially the stamp of approval by the Treasury, or are boards content to rely on advice of counsel and act accordingly?
Mm-hmm. There's no specific mechanism for pre-approval. You are expected to rely upon the technical advice of counsel. In this case, we not only had counsel involved, but we had the auditor involved looking at it to confirm the independence test was met. And I have no reason to believe it wouldn't be upheld. Treasury, it's unfortunate that the spin an article takes when somebody comments off the cuff. I mean, in this case, they make it sound like they go out and look and discover these things. I think that was the verb that was used. And that's very unfortunate. There's no reporting requirement. They could have one if they wanted one. I think, as my experience in Abbott districts has taught me, a lot of New Jersey's governance these days is governance by ambush. And that's very unfortunate because it's not an orderly process. It doesn't give you the opportunity to do things the way that everybody wants to everybody's satisfaction. But no, the process employed here was a pretty standard process. It's employed by most districts in engaging in this kind of arrangement, and I know of no departure from normal practice.